Hello viewers, welcome to our channel Rising Legal. Today in this constitutional law class, I am going to discuss an important topic. The topic is fundamental rights. Viewers, fundamental rights are actually inserted part 3rd of the Indian Constitution, which mention under Article 12 to 35. Now, what is fundamental rights? Fundamental rights are of immense value. They are actually limitation upon the state action. Part 3rd of the Indian Constitution described as the Magna Carta of the Indian Constitution. Generally, Part 3rd of the Indian Constitution contains fundamental rights, which falls under Article 14 to 35. Actually, Article 12 to 35 deals about fundamental rights, but Article 12 basically deals about state, and Article 13 of the Indian Constitution deals about judicial review. Now the question is that why these are fundamental? These are fundamental as they are essential for the overall development of the human beings. And viewers, these rights are actually available against the state and not against the private individual. The state has no power to curtail the fundamental rights of the individual except on the ground permitted by the Constitution itself. In Kesavananda Bharati versus State of Kerala, AIR 1973, in this particular case, Honorable Supreme Court held that fundamental rights are the basic structure of the Indian Constitution. Now, next is that it is to be noted that fundamental rights in the modern name for what have been traditionally known as natural rights. Fundamental rights provided security and equality of citizens to the people living in India. In England, there is no personal enumeration of any fundamental rights of the people. Now viewers, in Goloknath versus State of Punjab, AIR 1967, in that particular case, the Honorable Supreme Court actually classified various kinds of fundamental rights, which are as follows. First is that right to equality, Article 14 to 18. Then second, right to freedom, Articles 19 to 22. Third, right against exploitation, Article 23 and 24. Fourth, right to freedom of religion, Article 25 to 28. Fifth, cultural and educational right, Article 29 and 30. Number 6, right to constitutional remedies, which falls under Article 32 to 35. Now viewers, it is to be noted that the Indian Constitution was the most lengthy written constitution in the world. Actually, this credit actually goes to the Yugoslav Constitution, which has surpassed our in its length. The original Constitution actually contained 395 articles and 8 schedules. And fundamental rights model actually borrowed from the American Constitution, the parliamentary system of the government adopted from the United Kingdom, and directive principle of state policy actually taken from the Irish Constitution. Now viewers, I am going to another phase regarding the discussion of the fundamental rights chapter. What are the exceptions to the fundamental rights? Because I already mentioned that Indian Constitution granted 6 fundamental rights for its citizen. But at the same time, some exceptions are also there to the fundamental rights. What are those exceptions? First is that Article 31A, 31B and 31C, these first two introduced by the First Amendment and the third by the 25th Amendment are meant to validate and save certain laws which may otherwise be ultra vires the Constitution. Now, Article 31A protects certain laws dealing with acquisition of property by the state, abolition of the Jamindari system, etc., regardless of what is provided by the fundamental rights in Article 14 and 19. Now, next is that Article 31B saves the Act and regulation placed in the 9th Schedule of the Constitution. These laws shall not be deemed void on the ground of any inconsistency with the fundamental rights. Next is that a law placed in the 9th Schedule cannot be questioned for its validity in court. However, for a law to get protected by Article 31B, a constitutional amendment is required to place the concerned law in the 9th Schedule. And Article 31C protects a law if it has been made to implement the directive principle in Part 4. Now, viewers, I am actually discussing another phase of that particular topic, that is the fundamental rights, and this is what are the distinction between fundamental rights and ordinary rights. First distinction is that fundamental rights are fundamental or basic rights, but ordinary rights are not the basic rights. Second thing is that the fundamental rights cannot be waived, but the ordinary rights can be waived. And third distinction is that in case of infringement of an ordinary rights, a person can claim the remedy from the ordinary courts. But on the other hand, if the fundamental rights is infringed, the remedy is available under Article 32 and 226 of the Indian Constitution. So viewers, that is our today's discussion, the concept of the fundamental rights and other important aspect regarding fundamental rights. Hopefully you all actually understand today's topic. Thank you to all the viewers who are actually supporting us and viewed our channel Rising Legal. Thank you to all of you.